Chibaule.
I seek a lordship's indulgence in making a mention, my lord. Item 9 of part 2 list, hearing list.
Yes.
This is a criminal appeal by the state, my lord. I cannot contact the other counsel. If this can be adjourned after a week, my lord.
As prayed for by MS Linda L. Samuel, Leonard PP for the state, repost on such and such date.
8th of June.
All right. Okay.
May I seek your lordship indulgence in mentioning part 2, item number 14. This case is taken
Miss
by
Mary?
Miss, yes, due to some personal
Okay,
difficulties.
which one? Item number?
14, 1-4.
14. Yes. Have you informed Mr. Jordan?
Yes, your lordship.
As prayed for by Mr. Jordan, there's a prayer for item 14. I cannot hear you. I can see you. You are visible in the screen, but you're not audible. Sorry, unmute yourself. Something wrong? Where's the computer guy? Can you hear the court? I think there is some difficulty at your end. Sorry, we cannot hear you. Anyway, you've taken his consent.
Yes, your lordship.
Your name?
Daniel Shassel.
As prayed for by Mr. Daniel Leonard Counsel on behalf of Miss MS Mary Leonard APP for the state respondent, which is not opposed by Mr. Jordan Leonard Amicus Curie for the appellant, repost on such and such date.
11th of June.
And item number 15. This is also taken up by
Item number?
15.
Similar prayer, and Mr. Victor, instead of Jordan, you put Mr. Victor L. Lalte, Leonard Amicus Curie.
16th of June.
And in both you say on medical grounds, huh? She's unwell, isn't it?
Yes, her daughter is sick. Oblige, your lordship.
You had mentioned about her daughter when I was sitting in DB, but yesterday somebody said that even she is unwell.
Yes, your lordship. Her daughter, at first, her daughter was.
Anyway, all right, next.
Oblige, your lordship.
I seek your lordship's indulgence in mentioning item number 12, part 2. So I'm appearing on behalf of my senior, Ruben Lerden Sanga. Due to some personal difficulties,
A mention is made on behalf of Mr. Ruben
Lerden Sanga,
Sanga, Leonard Counsel, appearing for the appellant, which is not opposed by Leonard State Council, repost on such and such date.
so my lord, I pray for an adjournment of the matter for 2 weeks.
I've already given the
Okay,
order.
thank you, my lord.
Do you want me to
16th
recall
of June.
it?
16th of June.
Lord, I beg your indulgence in mentioning item number 21, part 2, hearing list.
20?
1, part 2. My lord, with the consent of the other party.
Ruata? Tuanga, the sound is not proper.
My lord, with the consent of the other party, this matter, if it may be taken again after 2 weeks.
As prayed for by Mr.
Ronald Ranpuya.
So and so, Leonard Counsel, on behalf of Mr. B. Lalremanga, Leonard Amicus Curie, which is not opposed by the State Council, repost on such and such date.
18th of June.
Obliged, my lord.
You take his name.
May it please your lordship, I am appearing on behalf of FLL Indiana and
Item.
item number, part 2, item number 19. This matter may be listed in a fixed date.
A mention is made by Mr. So and so, Leonard Counsel, on behalf of Mr. F. Lallengliana, Leonard Amicus Curie, which is not opposed by the other side, repost on such and such date.
9th of June.
Your lordship, it may be listed on a fixed date, that is 16.
Next.
And your lordship, one more item, that is part 1, item number 13. This matter is listed for hearing today. It may be listed again on 25th of 6.
What is the auspicious on 25th?
There is my, there is the instruction.
This
I
is
got
your
from-
instruction.
Yes. you have it.
As prayed for by Mr.
Sil Sangpuya.
Leonard Counsel, on behalf of Mr. F. Lallengliana, Leonard Counsel for the appellant, which is not opposed by the other side, repost on such and such date.
25th June.
Obliged.
You've informed the other side or not, Mr. Counsel?
Yes, Your Worship.
You've informed?
Taylor list for admission, item 1.
Mr. Victor, some development was supposed to be,
And my lord, there is a recent draft award number 1 of 2026, and DC Longklai had sent for seeking for approval of the same on 30th of January 2026, approval of that draft award, which is still awaited, my lord.
still awaited.
Still awaited, my lord.
Ms. Angpi, I'll post it on another date, Ms. Linda, because the developments, as mentioned in the last court's order, is still awaited. Heard Mr. Victor L. Lalti, learned counsel appearing for the petitioner. Also heard MS Angpi, learned counsel appearing for respondent number 6 and 7, and MS Linda L. Famwell, learned.
For
You are
respondent
appearing
number
as additional advocate general?
My lord, I'm for respondent number 8.
Ms. Angpi, you are for respondent number?
8,
Only 8.
yes.
Because in the last court's order, it is set 6 to 7. Anyway, 8 Koidima, Sangpui. And Miss Linda, you are for
1 to 5.
1 to 5. So who's appearing for 6?
6 and 7 is another council, my lord.
He's not there. None appears for respondent number 6 and 7 on call. Mr. Victor, Leonard so-and-so submits that the development as was required to be placed before this court as per the court's last order dated 25/2/2026 is still awaited. Repost on such and such date.
5th of June.
Deeply
Item 2.
Right.
Mr. Malhotra, affidavit in opposition has been filed.
Not yet, my lord.
Not yet. How much time? Something is, I think, wrong today with the
Very sensitive.
very sensitive. Yes.
My lord, I have to seek another 2 weeks' time.
Any objection, Mr. Malhotra? Heard Mr. A.R. Malhotra, learned counsel appearing for the petitioner. Also heard MS Linda L.F. Famwell, learned AG, additional AG for the state respondent. MS so learned additional AG, seeks for the, how much time?
2 weeks' time, my
2
lord.
weeks' time to file return in the matter. Prayer is not opposed. Repost on such and such date.
11th of June. Item 3.
3 is also the same, I think.
Respondent 6 and 7.
My lord, I'm for respondent number 6 and 7. I may be given 3 weeks' time.
State's affidavit is already on record.
Yes.
Heard Mr. A.R. Malhotra, learned counsel, A.R. Malhotra, learned counsel appearing for the petitioner. Also heard MS Linda so-and-so, learned counsel appearing for respondent number
1 to 5.
1 to 5.
1 to 5, and MS Sangpui, learned CGC for respondent number
6 and 7.
6 and 7. Though state affidavit in opposition has already been filed, however, MS Sangpui, learned CGC 6, how much time?
3 weeks' time
3
may
weeks'
be
time to file return on behalf of the respondent CGC. Respondent Central Government Kuridiba. Prayer is not opposed. Repost on such and such date.
18th of June. Item 4.
Mr. Victor, are you going to file a rejoinder to the counter affidavit?
A small rejoinder I would like to file.
You'll be filing it? Mr. Lalpakwala?
It's okay, my lord.
Heard Mr. Victor so-and-so, learned counsel appearing for the petitioner. Also heard Mr. Lalpakwala, learned counsel appearing for respondent number
1 to 4.
1 to 4. C. Lalpakwala. As prayed for by Mr. Victor so-and-so, repost on such and such date to enable the petitioner file rejoinder to the affidavit in opposition filed by the respondent numbers 1 to 4.
Obliged.
16th of June.
My
Item
lord,
5.
my lord, there's an interim order which may be
Interim, if any, shall continue till the next date of listing.
deeply obliged.
Item 5.
We can call it once again, I think. No?
Item 6.
Yes, what about paper book? I think the trial court records have come. No? Yes, have come. Ms. Linda,
Yes, my lord.
this is an
It's
NDPS.
for, yes, it's for
Service is also complete. Paper book,
NDPS, yes.
paper book will be required.
Yes, my lord.
Heard Mr.
Elias Laram Sona on behalf of my senior.
So-and-so learned counsel appearing on behalf of, you're appearing on behalf of MS Fanai.
Yes,
MS Fanai, learned amicus curie. I also heard MS Linda, Learned PP for the state respondent. It appears that the trial court records have been received. Let the registry prepare paper book and furnish the same thereof to the learned counsels appearing for the parties. List after the paper book is prepared.
Obliged.
For orders, item 7.
Date is required to be given. "44 days.
Lordship, yes.
Mr. Victor, serious objection.
Yes, my lord.
How serious?
My lord, it's an appeal against acquittal.
Yes, that's why I'm asking.
And
It's an appeal, criminal appeal, statutory appeal.
yes, my lord, in the impugn judgment, my lord, irrespective of the present application is for condonation of delay, my lord. There is no production of the seized article during the entire trial. That is the one of the reason for acquittal of the accused. And my lord,
So
here,
this is a acquittal.
yes, my lord.
And against the acquittal, they have sought
Leave.
which was allowed.
Not yet.
Not yet allowed.
For the leave application, there is delay of this 300 plus for this delay.
Just, yes, what are your grounds?
Lordship, yes, I have explained the grounds of delay sufficiently.
Let
May
us
take-
see
Yes,
how
Lordship.
sufficient it is.
Lordship, may take Lordship to page 3
Yes.
of the
Yes, yes.
appeal, Lordship. I may read, Lordship. Start from the paragraph 2A.
Yes.
That the learned Chief Judicial Magistrate Champai had passed an impugned judgment and order dated such and such in the case of Union of India versus such and such. In fact, the impugned judgment and order dated 25/01/2024 was received by the Office of the Assistant Commissioner, Customs Division, Aizawl on 15/2024. As such, 51 days had gone unintentionally from the date of judgment and order dated 25/1/2024. Lordship, the said judgment and order dated 25/1/2024 was passed. However, on that very day, it was not furnished to both the councils. And there is no special PP at Champai, and I usually travel to Champai to represent the department. And usually this judgment and order, the other judgment and order was also sent to post office, Lordship. And that's why they have received on 15/3/2024. And as such, 51 days had gone unintentionally. Then I have annexed the extract copy showing the date of the receipt, Lordship, which is at page 18, annexure 1. I have annexed. The department had put the signature along with the seal. And at page 4B, that on 5/7/2024, the Office of the Assistant Commissioner, Customs Division issued a letter dated such and such requesting for legal opinion to the departmental counsel. However, owing to court closure from 08/07/2024 to 17/7/2024, the letter was received by the departmental counsel on 23/07/2024. And
Mr. Victor, sufficient grounds have
yes,
been given.
Lordship.
Yes, now we cannot start examining these grounds through a microscopic lens and seek an each day explanation. Undoubtedly, whether it's government or a general litigant, the discretion has to be exercised in the same liberal manner, isn't it? There is no special exemption for the government to go slow, but nonetheless, we know how the files move. Be that as it may, it seems that it has moved in a sufficient pace. The judgment itself was received little late.
The counsel who is representing the department before the National Trial Court and the present counsel are one and the same.
That's what, but
Very true.
he-
Yes, I
you
have-
see,
And my lord,
Mr. Victor, he has fairly submitted that he travels from here to Champai to do the case. The thing is that the judgment was not delivered on that day. It was sent through post. He received it on 15, after about 51 days.
And my lord, the department, the applicant herein, after receipt of the impugned judgment and order, they have sought the legal advice after lapse of more than 100 days.
Oh, this is 15th March, and the legal advice was sought in July.
2024.
Yes, why so late? After almost how many months?
111 days.
181 days is calculated from the date of
No, but what were you
judgment
doing
order.
for this long days? Unintentional? What unintentional? 181 days.
Your Lordship, the usual process is the impugned judgment and order was received by the
No,
office of the commissioner. Then they
Mr.
have sent to the Shillong.
Mr. Johnny,
Lordship, yes.
Mr. Johnny, you see, as far as your paragraph A is concerned, 51 days. All right, understood. Post 15/3/24, you took 181 days to seek that legal opinion. What were you doing? I'm not saying you as
Yeah,
you.
I understand,
The office.
Yes, yes.
181
Also,
days.
the
Now, if something has happened, that explanation has to be on record. Mr. Victor and I cannot now start presuming
Yes, I
what was
understand,
happening during that period. 181 days is not a short period. It's
Also-
quite, as I indicated, I'm not asking a day-to-day explanation, but it has to be a reasonable explanation.
I understand, Lordship.
So where is the reasonableness in paragraph B? 181 days had gone.
Lordship, I may be given a chance to clarify so that I will write a letter to the department.
No,
regarding
I
that.
don't know
Why-
what
why-
clarification. Now you can't bring afterthoughts. Then that should have been a part of the. Anyway, you find out. But I can reject it right away. The only problem is
It's up to you,
rejecting
Lordship.
right now.
It's up
Mr.
to
Victor
you.
would foreclose the claim. So let me give him another opportunity. If they can substantiate their stand, well, good. But no concocted stories welcome in this court at
I
least.
agree, Lordship.
So
Fair enough,
be
Lordship.
reasonable. If there is something which can be explained, you can bring it by way of an additional affidavit.
Lordship,
but
yes.
don't-
I already wrote a letter to the
don't
department
stretch
regarding
it
that also.
too far. Heard Mr. Johnny L. Toswang, Learned Counsel, appearing for the applicant. Also heard Mr. Victor L. Ralti, Learned Counsel, appearing for the respondent. As the grounds urged for the delay for condoning the time for filing the connected leave application, for preferring the criminal appeal against the acquittal in question. The explanation as pleaded in paragraph 2 of the application prima facie is not inspiring the confidence of the court. Mr. So-and-so seeks a short accommodation to place further explanation. Seeks short accommodation in this regard.
Lordship,
He
yes.
also seeks liberty to file an additional affidavit if so advised.
Lordship, yes. Supply.
4th of June. Item 8.
328 days.
Lordship, yes. The
Mr. Pautu is here to object. Serious objection.
I'm also appearing in this case for one
You
of the
also have
respondents.
serious. Now, earlier you had only one counsel objecting you. Now you have at least two, huh?
counsels
Two
are
or three. What is this? This is also criminal appeal.
criminal appeal against the acquittal, Your Lordship. And this IA is for an application for condoning the
Yes,
delay
yes,
of 328 days. Also, page 3, paragraph 2A. The reason which explain.
131. Here also
130.
the same thing.
Lordship, yes. I may be given another, the same order may be passed, Lordship. So I'll try to explain. If not, then my case will go on.
Yes, Pautu. Come this side.
My lord, prior to this proceeding, a chance was given for them to amend the instant application. Yes, my lord. At the initial, only the section 419 was invoked, not the Limitation Act, when in fact section 5 of the Limitation Act has to be invoked. And my lord, the court has given the chances, and if during that period they have been diligent, at least the same could have been amended as well, my lord. This matter has been pending since last year, so my lord, rejecting the application at this stage would be proper, because it only
There's no difficulty in rejecting, as I have indicated in my, in that order, the same order will come here. Prima facie, I have indicated that it's not inspiring the confidence of the court.
my lord.
It's only, you see, at the end of the day, these are condonation applications. One must also be alive to the fact that the moment court rejects, that entire chapter ends. Correct. So we'll give them another chance. If they come up with something which is reasonable, we will see. Otherwise, we'll reject it. All right.
It's up to your lordship, yes.
Same order, huh?
same
But
order.
just add Mr. Pautu. You are for respondent?
Respondent number 2.
2.
Item number 9 and 10.
None appears on call. Repost on such and such date.
5th of June. Item 11.
Good morning, Lordship.
Yes. Mr.
Lordship,
Nath.
I am appearing. Yes, Nath. Vikram Aditya Nath. I am appearing from Kachar, Assam for the original engaged counsel for
You
the
are
item number
appearing from?
Kachar, Assam.
That's all right. This court does not know where you are. But this is item number 11.
Yes, yeah. This is item number 11 for bail application 28 of 26. Appearing for original engaged counsel. Original engaged counsel is not here due to some family issues. And that's
Ms.
why.
Vani, in this bail application, again, suspension of sentence is sought.
No, Your Lordship. This is a regular bail appeal, Your Lordship. Bail application.
No, but bail application, why setting aside quashing order? I have not followed. Have you seen the prayer at 17? Which is this order? Setting aside.
Lordship, today is the date. Today is the date fixed for case calling for case record.
Mr. Counsel, first of all, you please tell me this bail application, how come you are challenging the order? Bail application can be only for bail.
Yes, Your Lordship.
This is not a revision. Yes, Mr. Nath, I am speaking to you. Mr. Nath, is the court audible to you?
Yeah, sir, I'm just instructed for. Yes, yes, sir. I'm just instructed to seeking time for original engaged counsel. I'm appearing for in the matter of
Can you understand what
versus
he's
State of
saying?
Mizoram. So seeking time for.
Huh?
Not exactly, Your Lordship. And Your Lordship.
And neither can this court understand.
Yes, another thing which I would like to point it out is that even though they have stated that there is a previous bail application, however, they did not submit the order as well. They didn't even annex the order.
The manner in which the prayer is,
Yes,
how is that
exactly.
maintainable? Heard Mr. B. Nath, Learned Counsel, appearing for the petitioner through video conferencing mode. Also heard M.S. Vani, Learned APP for the state respondent. Mr. Victor, you are there? Mr. Nath, Learned Counsel for the petitioner, due to technical glitch, is not audible. It appears that in the bail application, an order passed by the special court rejecting special court by order dated 27/2/2026 rejecting the bail application of the petitioner is being challenged. The maintainability of the bail application assumes significance. However, since the Learned Counsel for the petitioner is not audible, repost on such and such date.
9th of June. Item 12.
Okay, thank you, my Lordship.
days.
Yes, Lordship, but however, Lordship, as the office note indicates that service was incomplete due to incomplete address.
Await service, repost on such and such
Lordship,
date.
I'd like to take a fresh steps since it is incomplete. So
Fresh
if,
steps.
if your Lordship allowed, I'd like to take back the unserved copies of the unserved copy of the petition.
You take fresh steps.
Yes, Your Lordship, but it
No,
was
you
returned.
take, it's all right. You take fresh steps again.
Yes, Your Lordship,
As
I'll
per
do
law.
that.
Yes.
But however, the unserved copy is with the.
Let it be there. We don't know. Whatever the procedure is in accordance with law, you take your fresh steps. You approach the registry. Yes.
Yes, yes, Your Lordship.
18th of June. Supplementary list, item number 14.
Yes, Ms. Fanai.
Yes, Your Lordship.
Have you recovered?
I'm so sorry to mention that I did not see the supplementary course list.
Huh?
I did not see the supplementary course list. I received the supplementary course list only this morning after reaching here. So the file is not yet with me. So if the matter may be posted after as the last item.
Yes, my lord.
When?
Today, as the last item?
After
This
two.
is the last item, I think.
Afternoon, Your Lordship, if it's possible in the afternoon.
At
Because-
2.
At 2. The file is not with me yet.
At 2. In fact, councils, in the event you have the file before that, you get in touch with Ms. Fena and you inform the court master. I'll assemble the court. We can have it before that also.
Yes,
So
Your
you
Lordship.
get it.
Yes.
No point of waiting till 2 o'clock.
Yes, Your Lordship. Now it's coming. I will inform.
So you let the court master know the moment you have the file
Yes, Your Lordship. I'll
and
do
Ms.
that.
Fenai.
Yes, I'll do that.
This court is here, so we can have it.
Item 5 for admission.
Still nobody is there. 5. None appears on call, repost on such and such date.
11th of June.
None appears for the petitioner despite the matter being called twice today.
Hearing list, item 11.
My lord, on behalf of Mr. A.R. Malhotra, if this item may be listed again after 2 weeks.
Item,
11, my lord.
a mention is made on behalf of Mr. A.R. Malhotra, learned counsel appearing for the appellant. Miss Linda, you are in this, she's not here. Who is appearing for the state here? It's a 2023 appeal.
My lord, Miss Linda, we have informed.
Conviction is under what? Why so much time is being sought? When do you want it? We're giving you a fixed time and no further time. The appeal is pending for a long time.
My lord, if this item may be listed after 2 weeks.
No, not 2 weeks, 1 week.
My lord.
A mention is being made on behalf of Mr. A.R. Malhotra, learned counsel appearing for the appellant on the ground of personal difficulty. It appears that the appeal is pending adjudication since 2023. Hesitantly, the matter stands adjourned to such and such date. However, it is made clear that on the next date of listing, the endeavor shall be made, no further adjournment on behalf of the appellant shall be entertained.
1st of June.
The file. You got it? Is this that case, that vernacular?
Yes,
The
my lord.
language you said you don't
Yes,
you
my lord.
have?
Article 22, yes, my lord.
Yes.
My lord, if I may start with from the beginning.
Yeah.
My lord, the accused was arrested on 15 December 2025.
15?
15 December 2025.
15 December.
2025.
Right.
For alleged possession of 200 grams, 200.16 grams of suspected heroin. And since then, he has been incarcerated. My lord, one point is that the grounds of arrest was not furnished to him and neither to his relatives. And arrest intimation was also not given to the relatives, but however, just the person who was traveling with him in the vehicle, which is a very distant relatives. So, and my lord, if I may take your lordship to page 17 of my application. Like we have said before, it's the grounds of arrest. My lord, here it's written that the inspect SI, this is the seizing officer, and he has stated everything that the address and everything. However, my lord, there is no documents on record to prove that the copy was furnished to him and that the accused have received the letter.
No, it is here. This is signature. His signature is here. The ground is mentioned here. Upon the reliable information received by me that you have committed offense under so and so by possessing, transporting suspected heroin, 216 grams at so and so. Specific information, date, time is given. What more specifics you need?
My
You have
lord,
signed it.
I have not signed it, my lord.
Your name is there, serial number 3. That's a signature. Joseph Lalring.
My lord, that's not my signature.
We don't know.
That's just the name.
That's not just the name. That is a signature. It appears.
My lord, his signature.
Where have you said it is not your signature? Which paragraph have you said?
My lord, in para number.
Miss Vani,
Para number 3.
one thing Miss Vani is right. In serial number 3, against the name is written. Against the signature, it is blank.
Yes, Your Lordship.
My lord, his signature in the arrest memo is there on page 24. That's his signature. Page 24. 23 is the arrest memo and the signature is on page 24.
Yes. That on top of the date. No. Which is his signature?
Signature
Of
or
arrested
left
person.
of arrested person on the right side, on top of the arresting officer.
Yes.
That's his signature. My lord, the grounds of arrest is just, his name was just written.
Well, how do you show that this was given to him?
Yes, Your Lordship. I have even talked to the case IO, and
There's nothing.
yes,
There's nothing on record to show.
yes, there is
In
nothing
that
to show that
case,
he has skipped his
without
signature.
further going into the merit, the petitioner is entitled for bail. The latest is Mahisha.
And my lord, we had also submitted a bail application of the principal seat, which is authored by your lordship. This Azibur Rahman, alias Aziz.
Give. But I have authored couple of them in your case also.
Yes, my lord. But this is very detailed one, my lord.
Yes, here, but here, I don't think I have taken Mihir Shah in this decision.
Yes, my lord.
Subsequent to that, Mihir Shah has also come, now.
Yes, my lord. My lord, from page 24, whatever I have.
One second. Third MSF Fanai, Learned Counsel, appearing for the petitioner. F Fanai, no, sorry.
L for nine.
L Fanai. Also heard MS Vani, Learned APP for the state respondent. By way of this application, under section 483 ENSS, the petitioner is seeking release of the accused petitioner I. Shri Joseph Lalrindeka on regular bail, who has been arrested on 15/12/2025 in connection with SR within bracket EX number 278/2025, registered under section 21B of the NDPS Act 1985. The brief facts of the case is that on 15/12/2025, one SI B Laleng Mawai received information of transportation of illicit articles from Champai heading towards Ketum SIB Ketum. Stop. The aforesaid official, along with his party, including civilian witnesses, went to the location wherein, upon checking the several vehicles for few hours, around 6 p.m., they encountered a suspicious vehicle, Wagoner BR number MZ04 capital A 9838, heading towards them, which was halted by the duty party. Upon asking the driver of the said vehicle to get out of the vehicle, he gave up. Now he gave he took out 7 soap cases containing yellowish powder suspected to be heroin from his pockets of his jacket and trousers. Upon further being suspicious and search of the vehicle, for another 10 soap cases containing suspected heroin was also recovered from therein. Accordingly, the accused petitioner was arrested on the accusation of committing an offence under section 21B NDPS for alleged possession of 200.16 grams of heroin, and since then have been detained in judicial custody. MSL Fanai, Learned Counsel for the petitioner, submits that it is apparent from the arrest, from the grounds of arrest, enclosed to the petition, that no grounds of arrest was furnished to the petitioner. She further draws the attention of the court that there is no signature or documentary proof to show that the grounds of arrest was furnished to him and his relatives, and hence such action is in gross violations of the constitutional mandate under Article 22(1) of the Constitution of India. In support of the aforesaid principles, she relies upon the decisions of the Apex Court, particularly in the case of Pankaj Bansal versus Union of India and others, reported in 2024, 7 SSC 576. Vihan Kumar versus State of Haryana and others, reported in 2025, SSC Online Supreme Court 269. Mihir Rajesh Shah versus State of Maharashtra and others, reported in 2026, Volume 1, SSC 500. And a coordinate bench and a decision authored by this court within brackets so and so in Ajiju Rahman LS Ajiz LS Ajibur in bail application number 624 of 2025. Per contra, MS Fanny Leonard so and so submits that the grounds of arrest was furnished to the petitioner. However, she has nothing on record to show that the said ground of arrest was actually contemporaneously furnished to the petitioner or to his relative during the time of his arrest.
Your Lordship, only for argument's sake, the intimation of arrest was given to the relatives.
Where?
That Lal Engliani, that is the, here in the arrest memo, that is in page 23, it is stated that intimation
She
of
further
arrest
submits that the intimation of the arrest was also given to one
Lal En Kimi,
Laling
Lal En Kimi,
Lalan Kimi,
who is the accused person's wife, elder sister, daughter.
who is the petitioner's wife's elder sister.
Elder sister, daughter.
Elder sister's daughter. Stop. Upon hearing the learned counsel appearing for the petitioner and having appearing for the parties and having perused the materials available on record, including the case record submitted before the case diary, na? These are what?
Scan copy of TCR.
Including the scanned copy of the TCR. It is apparent. No, it appears that while it appears that no grounds of arrest was mentioned in the arrest memo, which reads as under, quote unquote, page 23. It is true that the intimation of arrest is given to one so and so, who is stated to be the petitioner's wife's elder sister's daughter. It further appears that the ground of arrest stated to have been furnished to the petitioner under section 47 BNSS section stroke section 52 1 NDPS Act, though mentions the reason of arrest. However, on a careful perusal of the aforesaid document, it appears that the column against the signature of the accused petitioner is blank. The aforesaid document is reproduced hereunder for ready reference, page 17, quote unquote. It is thus evident that there is no signature or documentary proof to show that the grounds of arrest was in fact furnished to him and his relatives. Hence, the only issue for determining in the instant petition is whether non-furnishing the grounds of arrest to the petitioner violates the arrest itself. The aforesaid issue is no longer res integra in view of the decision of the apex court in Pankaj Bansal Supra, wherein it has been clearly held by the apex court that the requirement of informing a person arrested on the grounds of his arrest in writing is a mandatory requirement under Article 22(1) of the Constitution of India. The apex court further emphasized that when a violation of Article 22(1) of the Constitution of India is established, it is the duty of the court to forthwith order the release of the arrestee, and that statutory restrictions also shall not affect the power of the court to grant bail when the violation of Articles 21 and 22 of the Constitution of India is established. Within bracket, refer Vihan Kumar versus State of Haryana and others, reported in 2025 SSC Online, Supreme Court 269. It is apposite also to refer to the latest decision of the apex court in the case of Mihir Rajesh Shah Supra, wherein the apex court has reiterated the constitutional mandate of informing the arrestee of the grounds of arrest in writing as mandatory. Relevant paragraph of the aforesaid judgment read as under quote unquote 5566. It is thus an undisputed position that in the present case the accused petitioner was not given the grounds of arrest in writing during his arrest, and hence his arrest is vitiated. Before that you said, undoubtedly when the arrestee alleges that the ground of arrest is not given to him in writing as per the constitutional mandate, the onus is on the investigating agency to establish before the court, to show before the court that such procedural statutory stipulation under the constitutional mandate has been followed. As stated above, in the present case, no such records contemporaneously to the arrest of the petitioner has been brought on record to show that he has been informed of the grounds of his arrest as required under Article 22(1) of the Constitution of India. It is thus undisputed. Keeping the aforesaid principle in mind, I do not find any therefore, on this score alone, further detention of the accused petitioner in the custody is totally unjustified. Accordingly, the accused petitioner, namely so-and-so, shall be released on bail in connection with the aforementioned case, furnishing bail bond of rupees 50,000.
Yes, sir.
With two sureties.
Yes, with the satisfactory of the learned trial court. With the satisfaction of the learned trial court.
Of like amount each, provided one surety has to be a government servant.
Normal, permanent resident with LSC. LSC. My lord, permanent resident of ISO. If possible, he is like Indian.
Why not government servant?
My lord, it's very difficult for them to execute bail bond.
Yes, Your Lordship, my prayer is with the satisfaction of the trial court, so that the trial court can make it their satisfaction, with their satisfaction.
No, should I say with two sureties of like amount each provided at one, or should I not say that?
Government servant, yes.
My
One
lord,
government
if
servant.
Your lordship can be silent on that.
With two sureties of like amount each to the satisfaction of the learned um, special court NDPS
Aizol.
Aizol, na?
No, my lord, circuit court.
Just ask your junior to write the name of the court.
Yes, my lord.
Under the following conditions, Didiba, that the accused petitioner shall appear before the learned trial court on each and every date to be fixed by it, that the accused petitioner shall not directly or indirectly make any inducement, threat, or promise to any person acquainted with facts of the case so as to dissuade them from disclosing such facts to the court or to any police officer. That the accused petitioner shall not leave the jurisdiction of the learned trial court without prior permission. That should be sufficient.
Yes, Your Lordship.
It is made clear that in case of any violation of the above mentioned terms and condition by the accused petitioner, the bail granted to him shall automatically stand vacated. In terms of the above, the bail application stands disposed of.
Deeply obliged, my lord.
Because I remember in few earlier matters with this condition of government surety, later on the petitioners again have to approach
Yes,
with
my lord.
IA to relax that because they can't find it. And that permanent residence also, that clause also sometime.
Yes.
Once it's a case where liberty is concerned, Article 21(2) is violated, then perhaps the conditions must be also realistic. We should not probably give something which we know they may not be able to do it, because considering this from the background of this place, in earlier cases I have seen that these clauses are not always met with, and they come up with IAs.
I understand.
So I think this is sufficient. Let the trial court satisfy with
Yes.
the surety. All right.